Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case Lucia versus SEC. This case was heard in the Supreme Court of the United States in the year 2018. Let's go ahead and jump into the facts of the case. Mr. Raymond Lucia was charged with violating our country's investment laws. Okay, so the SEC, in case you didn't know, is an executive agency that is established by Congress that was built to administer our country's securities laws, to make sure that investors aren't getting defrauded, and to protect those investors and their funds from, hawks or fraudsters in the investment world. So Mr. Raymond Lucia, he was charged basically as one of these hawks or one of these fraudsters, and he was brought before an SEC tribunal. So the SEC itself has administrative law judges. These judges might administer proceedings and might look at the facts of the case and basically make a preliminary ruling. Now, the ruling of the ALJ, so the ALJ might say, well, we believe Mr. Lucia committed fraud, would then go up to the SEC Commission. Now, the SEC Commission is the head of the SEC. All of these folks are appointed by the president. And then the SEC Commission would either ratify that decision or they would say we reject that decision. Mr. Lucia didn't like the decision of Judge Elliott. Judge Elliott basically ruled completely against Mr. Lucia. And so he got some smart lawyers, and the lawyers said, well, let's challenge this decision and say that Judge Elliott, the administrative law judge of the SEC, was not properly appointed underneath the Constitution's Appointments Clause. So that was the argument. And the reason they're arguing that Judge Elliott was not properly appointed, the ALJ, was because he was basically appointed by SEC staff. He was not appointed by the SEC Commission, the commissioners themselves, the people that were appointed by the president. Rather, the ALJ, the administrative law judge in this case, was appointed by the staff members. And these staff members, they just applied and got jobs. None of these folks were appointed by the president. And so Mr. Lucia's argument is that there's not like a valid string of power from the president to the commission to the ALJ. There needs to be that valid string of power. They're not arguing that he's a superior officer. They're arguing he's just an inferior officer, and he could have been appointed by the commission himself, but he needed to at least be appointed by people who were appointed by the president. He can't be appointed by people who were staff members that were just hired by the SEC. That violates the Appointments Clause, is his argument. And the majority of the court, 7 members of the court, find that argument to be persuasive. Justice Kagan writes for the majority, and she says, we have generally looked, when we're looking at people, if they are officers and if they need to be appointed, and if we're going to classify someone as an officer. And so that's really the question here. Are we going to classify these ALJs as officers? We generally look if they have significant authority under the laws of our country. If they have a continuing office and significant authority. That is kind of the 2 prongs of the test. And Justice Kagan says we're not going to really define significant authority very well. We haven't done so in the past, and so we're just going to continue to say we won't define this well. But our nation's precedents, our Supreme Court precedents here, namely a case called Freytag, in that case, basically the IRS's equivalent of these administrative law judges, were labeled officers. The court held that they were officers, and they needed to be appointed in accordance with the Appointments Clause. And so she says that precedent really controls here. I mean, we don't need to define the significant authority test much further because that case is like this case. And there's some good reasons for thinking this. Although the decision of the administrative law judge herself is not binding, it is just immediately referred up to the SEC. And in practice, the SEC doesn't really deny any of what these ALJs do. They just generally affirm them. And if they just sit on the SEC's commission's desk for a while and the desk doesn't touch it, they just kind of become binding. It's kind of like a bill that sits on the president's desk that doesn't get signed. I mean, this ALJ decision might just become binding without any SEC action. And these judges really do have the power and authority in these proceedings in an SEC ALJ court or tribunal to basically shape the record. they can allow witnesses to testify. They can say other witnesses, you can't testify. And so you can see how they can really shape the record. And they do have significant power in that, right? No one is observing them and like making sure that they're doing everything all right in the hearings. The record just gets up to the SEC, and the commission might say, hey, we agree with this or we don't. And so that's really what the majority finds persuasive, is there really is significant authority here exercised by the SEC ALJ and saying, yeah, we are going to hold you responsible and impose criminal liability and possibly throw you in jail for violating our country's investment laws. And so, these are big decisions that are made and essentially almost always ratified. And so this person is an officer, and they need to be appointed in accordance with the Appointments Clause of the Constitution. Justice Breyer, basically, he has kind of a unique opinion, kind of just classic Justice Breyer. He's like, well, we don't need to look at the Constitution. The Administrative Procedure Act says that these people need to be appointed by those who are officers. They weren't here, so we can just say that, we don't have to get to the constitutional question. We can just say that the appointment of the SEC ALJs violates the APA. He also has big concerns about not addressing the removal question, right? If these folks are officers, these ALJs are officers, who can remove them? And that's a really interesting question. Because if the president can remove these ALJs, then all of a sudden they become politically partisan. And that could be bad or good. There is still a line under this precedent, under the majority's opinion, that, there's some insulation, right? Because you have the commission who's appointed by presidents, and then the commission, could appoint these ALJs. But, there's still a little bit, there's a question here as to, are these people going to now become more political? And that's not what he really wants. Justice Breyer really likes a government filled with experts, neutral experts that, can kind of look at the facts and the science and make sure that we're getting it right. Justices Ginsburg and Justice Sotomayor write a dissent where they're saying this is not significant authority. This is not significant authority because the opinions of the ALJs themselves are not final. They have to be ratified by the SEC. And so significant authority requires final binding decisions. And because the ALJs can't make final binding decisions, they're not officers. Obviously, that wasn't persuasive to the rest of the court, but that's the approach that those two justices would have taken. And then finally, interesting is a concurrence written by Justice Thomas and Justice Gorsuch. And they basically adopt a test from Jennifer Mascott. She's a law professor, which basically she did an interesting law review article where she looked back at the original meaning of the Appointments Clause and what would originally have been understood to be officers to our founders. And they pull her line of reasoning from that, and they say, we like it. If it's a federal official that has an ongoing statutory duty, simple as that, that person is an officer. It basically would get rid of the significant authority, and you would just say, if you have a duty that is ongoing and it's established by statute, you are an officer. And so in that way, you would need to be appointed in accordance with the Appointments Clause. Now, the interesting thing about this concurrence is obviously that would have very vast reaching implications. Lots of folks that are just in the civil service who just have had jobs for years now would have to basically be appointed in accordance with the Appointments Clause. Would that be a big problem? Maybe. We might have people at the lower levels of government at these agencies that maybe don't have views that are in accordance with the administration. Maybe they don't get appointed, and there's this whole weird line thing where we basically get rid of the civil service protections in a sense. Might be a little bit of a slippery slope, but the argument by Justice Thomas and Gorsuch kind of does begin to open up that door and look critically at the civil service protection. So thanks so much for watching this video. I hope you enjoyed it. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.